with the offense of burglary. To that accusation, the defendant has pleaded not guilty, and by that plea, the burden is then placed on the state to prove the defendant guilty beyond a reasonable doubt to the jury before you can find the defendant guilty. The indictment, which will be in the jury room with you and which you had read to you at the very beginning by the clerk of court, is an accusation against the defendant and is not any evidence against the defendant. The evidence which you are to consider is the testimony of the various witnesses who testified in this case, together with the exhibits that were placed in evidence. Now, as I told you earlier, this defendant, as well as every defendant in every courtroom in the United States of America, comes into court clothed with a presumption of innocence, and this presumption of innocence continues throughout the case and entitles the defendant to a verdict of not guilty unless and until it is dispelled by evidence satisfying you, the jury, beyond a reasonable doubt that the defendant is guilty of the offense with which he is charged, that is, burglary. You have heard a number of us use the expression reasonable doubt. Reasonable doubt is to be given its ordinary meaning. It means a substantial doubt arising out of the evidence or lack of evidence in a case. It is sometimes described as a doubt for which you can give a reason. A reasonable doubt is not a fanciful doubt or a whimsical doubt or a weak doubt or a slight doubt. It is a substantial doubt arising out of the evidence or lack of evidence in the case for which a person honestly seeking to find the truth can give a reason. Now, if you have such a doubt, that is a substantial doubt in your mind, then you must resolve that doubt in favor of the defendant and write a verdict of not guilty. As I told you, the indictment charges the defendant with having committed the crime of burglary, and I tell you that in order for the state to receive a verdict of guilty of that charge, the state is required to prove all of the offenses, required to prove all of the elements of that offense beyond a reasonable doubt. Burglary is defined as the breaking and entering of the dwelling house of another in the nighttime with the intent to commit a felony therein, whether the felony be committed or not. To constitute burglary, there must be 5 elements. 1, a break-in. 2, an entry. 3, the entry must be in the nighttime. 4, the breaking and entering must be of a dwelling house within the definition, which I shall give you in a moment. And 5, the breaking and entering must be with the intent to commit a felony. Now, counsel for the defendant has conceded that there was a break-in, that there was an entry, and that the breaking and entering was in the nighttime, so there is no factual dispute or no controversy regarding this matter. So I tell you, as a matter of law, those 3 elements have been determined. That is, you may accept as a fact, based on counsel's concession, there was a break-in, there was an entry, and that it was in the nighttime. As I told you, the 4th element is that it be a dwelling house. So I tell you that as a necessary element to the crime of burglary is that the breaking and entering was to a dwelling house, that is a place lived in or regularly intended to be used as a dwelling place, and that the house is the house of another, that is the person or persons named in the indictment are the owners thereof. Okay, this will be some literary warm-up for the record. Racial discrimination is another obvious area where merely to cease and desist is not enough. If a firm has engaged in racial discrimination for years and has an all-white workforce as a result, then simply to stop illicit discrimination will mean little as long as the firm continues to hire its current employees' friends and relatives through word-of-mouth referral. Many firms hire in just this way, regardless of their racial policies. Clearly, the area of racial discrimination is one in which positive or affirmative steps of some kind seem reasonable, which is not to say that the particular policies actually followed make sense. Many different policies have gone under the general label of affirmative action, and many different institutions, courts, executive agencies, and even private organizations have been involved in formulating or interpreting the meaning of the label. The conflicting tendencies and pressures of these various institutions have shifted the meaning of affirmative action and produced inconsistent concepts as well. There is no way to determine the meaning of affirmative action. All that can be done is to examine the particulars, the concepts, the intentions, and the actual effects. In a society where people come from a wide variety of backgrounds and where some backgrounds have been severely limited by past discrimination, the very definition of equality of opportunity in a company which previously refused to hire minority individuals means that present and future discrimination occurs because of past discrimination. In 1969, the Court of Appeals struck down such a system on grounds of its current discriminatory effect. In another 1969 case, the Supreme Court struck down a mental test for votes in a community with a long history of providing segregated and inferior education for blacks. Again, the rationale was that the test presented present discrimination. Considering the community's past behavior, this question touches the crucial question of what to do when the effects of past discrimination are reflected in current individual capabilities. Is equal opportunity itself discriminatory under such circumstances? If so, is anything more than equality of treatment justifiable under the 14th Amendment and corollary statutes and court rulings? Be a little more warm-up, some legal material for the record. Robbery has two aggravating circumstances that would distinguish it from larceny. In other words, all of the elements of larceny must be present, plus two additional. One, the property must be taken from the person of another, but if it is taken in his presence, it is taken constructively from his person. And two, the taking must not only be without his consent, but it must also be accomplished with violence or by putting him in fear, violence meaning physical force or violence, or by putting the victim in fear. Then armed robbery includes all of the elements of robbery and larceny, plus an additional aggravating element, which must be established under Section 1611, 330, reading as follows. Any person convicted of the crime of robbery while armed with a pistol, dirk, slingshot, metal knuckles, razor, or other deadly weapon shall be guilty of the offense of armed robbery. I would further charge you that if the state establishes by the measure of proof, of which I have previously informed you, a larceny of goods described in the indictment, and if by that same measure of proof the state established possession of such goods by the defendant, and that the same were recently stolen, I would charge you that where one is found in possession of recently stolen property, an inference or presumption of fact arises that that person is the thief. (10120) class. This is some legal material. (10120) class. This is some legal material for the record. 120 class. This is some legal material for the record. Madam Foreman and ladies and gentlemen of the jury, the state of Louisiana, by this indictment, has charged the defendant, Wilton L. Farabee, with the offense.
The thing I love most about Humphreys College, the court reporting program, is the flexible schedule that I was able to go to school and work at the same time, and the teachers. They were just great and really helpful. Well, I went to a JC for 2 years right after I graduated high school, and I felt like I was just at a dead end. I felt like I was wasting time, wasting money. Court reporting was always in the back of my head, and it's just always been something that I wanted to do. And court reporting at Humphreys was just kind of straight and narrowed for me.
120 class. This is 120 class. This is some legal.
Okay, we're going to introduce another little body of briefs before we start True Voice. So, American, M-E-R-N, American, America, M-E-R-K, Asian, A-I-G-S apostrophe, Asian, A-I-G-S apostrophe, African, F-R-E-N, African American, F-R-E-R-N, African, okay, so you have two choices for African American. You can either stroke that F-R-E-R-N, or you may add the asterisk with that same outline. Oh, I see why. The asterisk indicates the hyphen, African American hyphenated. Hispanic, you may use either H-I-P-T or H-I-P-Z. Hispanic, Caucasian, K-A-I-G-S, Caucasian, K-A-I-G-S. American, America, Asian, African, African American, African American hyphenated, Hispanic, Caucasian. Were you able to tell if she was Hispanic? I am a Caucasian. He is an Asian. The restaurant serves American fare. The witness was African. The witness was an African American. Okay,